Hello, and welcome to my instructional video for intellectual property law. My name is Jordan, and this week I'll be taking you through a basic explanation of Section 44C of the Copyright Act 1968, as well as explaining what this section achieves in relation to parallel importation and the restrictions that Australia has regarding this. But before I talk about Section 44C, let me outline some basic definitions and concepts that will be relevant throughout the presentation. The first relevant term is article, which holds its ordinary meaning as a general item or object. Within the context of this video, articles are essentially products or merchandise that are imported and sold by different companies. An example of this is clothing. Another relevant term is accessory, which is defined in Section 10, subsection 1, and more extensively in Section 10D of the Copyright Act. An accessory is a separate item that often accompanies or is incorporated as part of an article. This can come in the form of a label, container or packaging, instruction manual or warranty, or specific electronic forms as outlined in Section 10D. A non-infringing accessory is an accessory that, according to the constraints set out in the Section 10 subsection 1 definition, is authorized by the copyright owner and is not legally enforceable. Finally, the concept of parallel importation should be explained. Essentially, this concerns genuine products that are sold or imported to countries that were not authorized by the initial manufacturers or copyright owners. A short example of this can be where a UK manufacturer has authorized all of its associated companies to only sell its product within the UK market. If one of these companies decides to sell the manufactured products to the Australian markets instead, this is called parallel importation. Currently, parallel importation restrictions exist in Australia, which means copyright owners have the ability to take legal action regarding the unauthorized importation of their goods and products. This is why Section 44C of the Copyright Act was created. Section 44C, subsection 1 of the Copyright Act states that the copyright in a work, a copy of which is, or is on, or embodied in, a non-infringing accessory to an article, is not infringed by importing the accessory with the article. What this means is that claims of copyright cannot be made against non-infringing accessories when they are imported with an article. Prior to Section 44C, copyright owners used labels and other accessories as a loophole to stop parallel importation of articles, where the copyright of the article itself could not be enforced. As such, the amendments made in 2000, including the input of Section 44C, were created as a way to prevent copyright owners from using accessories as a backdoor means of protecting exclusive distribution arrangements. An example of this section being applied is in the Polo Loren Company LP and Ziliani Holdings Proprietary Limited case. In this case, Polo brought an action against Ziliani, a parallel importer of genuinely purchased articles bearing the Polo logo, who were importing these articles from the US to Australia at a cheaper price and without authorization. Polo claimed copyright infringement on behalf of the logos, to which the federal court concluded that the logos were a corresponding design to the articles and were therefore non-infringing accessories and did not breach copyright. I hope this video has helped explain Section 44C of the Copyright Act, as well as highlighting why labels and other accessories are excluded from the restrictions on parallel importation.